on an every other day basis. Do you forgive me? Yeah, Mom, I think so.
Hold up. This isn't your usual courtroom start. The mood feels casual, even a little lighthearted. But don't get fooled. What's about to unfold is a serious plea deal involving a teacher accused of misconduct.
You want to get lost back there? Oh, you did? Yeah, you went back there. I was Judge McBurney go. Oh, yeah. I'm gonna have to wait. We're gonna have to wait now. The long court week. You've had court every day?
Mm-hmm.
Wow.
Our holiday, we had court Tuesday, Wednesday, Thursday, and today. It's like, but at least next week we don't have court. I'm catching up some stuff.
Did you get, I like her. Did you lighten your hair? It's pretty. I just want Bernie.
Hello. All right, let's see what's happening online. Ms. Bernett, you ready to take down this plea?
Yes.
Thanks for your patience. I think we have everything we need now. So let's get on the record. I need the new case number.
Yes, Your Honor. It's,
Hold on one sec. Gotta move this piece of paper out of the way. All right, our new accusation is?
new accusation number is,
25.
I'm sorry, 25, SC 005527.
All right, and it's still Nazareth Davis, who is here in court with...
Here's the bombshell. The defendant isn't pleading to sexual battery. Instead, it's reduced to 2 misdemeanor battery charges. That's a huge downgrade in severity. Why would the state agree to this? Likely because proving intent in the original charge could have been difficult.
Ms. Rios, we have Ms. Clark representing the state. And Mr. Davis, my understanding is that you are prepared to enter a plea to this new accusation, which I think is 2 counts of battery, not sexual battery, just battery.
Misdemeanor battery.
2 counts of misdemeanor battery. If the plea goes through and I accept it, I assume, although Ms. Clark will say so on the record in just a moment, the state will then dismiss the case of yours that's on the trial calendar that starts on Monday. In the case you've been in court for before, that you had the ankle monitor for, et cetera. Is that your understanding?
Yes, sir.
Okay. For us to go through the plea, Ms. Clark will put you under oath, ask you a bunch of questions about your rights and about this case. You'll need to answer those questions completely and truthfully. You need to let me or Ms. Rios know if you have questions about anything as we're going along. Will you do that?
Yes, sir.
Okay. Ms. Clark.
Thank you, Your Honor. And for the record, the state is null prosing the case 25 SC 0025033, which was for the single charge of sexual battery against child under 16 for the defendant Nazareth Davis.
Okay.
We'll be proceeding with the accusation of 25 SC 005527, 2 counts of battery, misdemeanor under 16.523.1. Defendant Davis, please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
You can put your hand down. Please state and spell your correct legal name.
First name is Nazareth, Nazareth. Last name is Davis, Davis.
We find out Davis nearly graduated college and presents himself as educated, composed, and cooperative. But here's the real question. Should higher education or life achievements ever influence how harshly someone is judged in court? What do you think?
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No,
Is there a medication that you normally take that you have not taken or been given today?
no,
How old are you?
60.
What's the highest level of education or the last grade that you completed?
My fourth year at Morehouse College.
Are you,
Hold on one second. Can you bend the microphone towards you?
Okay.
Thank you. So you attended Morehouse,
Yes.
almost graduated.
Yes, I need 15 hours before I graduate, Your Honor.
You're going back?
Yes.
Okay.
are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the following offenses? Count 1, battery, and count 2, battery.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the indictment with your attorney?
Yes.
And did you understand the indictment as explained to you by your attorney,
Yes.
or the accusation as explained to you by your attorney?
Yes.
And did you have an opportunity to review your waiver of rights with your attorney?
Yes, I did. Yes.
And did you understand the waiver of rights as explained to you by your attorney?
Yes, I did.
Is it your intent to waive your rights today?
Yes.
Have you had enough time to speak with your attorney about the charges in the accusation against you, including the facts and circumstances relating to these charges?
Yes.
Are you satisfied with your attorney's services?
Yes.
Attorney Rios, do you waive a formal reading of the accusation in this case?
Yes,
Do you waive any defects in the accusation for purposes of this plea?
yes.
Now comes the condition that really stands out. A psychosexual evaluation with a polygraph test. That's not standard for a simple battery case. Clearly, the court is signaling they are treating this as more than just a misdemeanor.
Defendant Davis, has your attorney advised you of the minimum and maximum sentence for the charge of battery to which you're pleading guilty today?
Yes.
The state will put those on the record. The minimum is 1 day in jail. The max is 12 months in jail. Do you understand that you're entering what is called a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For count 1, battery, the state's recommendation is 12 months probation with the special condition of the defendant must complete a psychosexual evaluation with a lie detector test and complete any treatment that is required or recommended. The state will assume the cost of the psychosexual evaluation. And for count 1, and also the defendant is to stay away from the victim child, in this case, Miss Reagan Barber. For count 2, the state sentence recommendation is 12 months probation that will be consecutive to count 1 in this case. And the defendant would be required to complete the special conditions and treatment. Defendant will be able to, if upon completion of any treatment or recommendations and no further violations of the law, the defendant will be able to receive a behavioral incentive date after 1 year. And the state will not oppose that. Is it your understanding of the terms?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that as there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty?
Yes.
This is where it gets serious. By pleading guilty, Davis is giving up nearly every constitutional protection, jury trial, presumption of innocence, the right to confront witnesses. One yes after another, locking him into the deal.
Are you currently on probation or parole?
No.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes, I am.
Do you understand that by entering a plea of guilty today, you are waiving all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter this guilty plea because you are in fact guilty?
Yes.
As to accusation number 25, my apologies. 25 SC 005527, how do you plead to count 1 battery?
Guilty.
How do you plead to count 2 battery?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
And here's the twist. The prosecutor openly admits they believe the correct charge should have been sexual contact by a teacher. But because of delays and complications, they settled for battery instead. Imagine being the victim hearing this. How would you feel knowing the case was reduced like that?
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes.
Your Honor, at this time, the state will provide a factual basis for the misdemeanor plea in this case, unless the defendant would like to stipulate to the factual basis.
I'll stipulate.
I do know that Judge McBurney, that you, even though we stipulate, you do want to have some type of understanding about the overall facts.
I do, and
Okay.
I know that we have Ms. Barber and maybe another family member on. They may want to be heard, so it helps me know a little bit about the allegations before I hear from any of them, if they choose to speak.
Yes, Your Honor, and there is a statement from the victim in this case. Just wanted to say, after my evaluation of this case, and the interviewing of witnesses, including there were other students at the school, that I believe that the appropriate charge in this case, based off of the fact that he was a teacher on staff, should have been the charge of the sexual contact of a student by a teacher versus this charge here. However, based on the fact that this case is from 2023, and
I think it's from 2022.
oh yeah, it started in 2022.
Right.
20 and based on the length of time, the state did not feel it appropriate to re-indict the case in this case. We want to emphasize that in this case, Reagan Barber was in fact underage of 16 years old, and she was actually traumatized by the contact that she received from the defendant. In this particular case, there was the victim child indicated that there was a hug or embrace that was done that was unwelcome by her, and it was done on more than one occasion. There's a report that at one point there was a hug and it was a touching of her butt, and then there was another account where she indicates that a touching was slightly above her butt. And so
Mr. Davis was was he a teacher of hers or a teacher at the school, but they did not have a student-teacher connection?
I'm not sure. I know that he was a coach on staff.
Okay, then I'll hear from Ms. Rios at the
He was a coach on staff. So the state acknowledges the fact that, of course, we would have had to prove the facts of this case at trial, and we're prepared to do so. But I believe that but for the fact that he was a teacher on staff, if you did not have a hug or physical embrace of the student child in this case would have even existed, because the hug itself is not appropriate and does not line up with what Georgia law mandates. And so, Your Honor, at this time, the victim has a statement.
Okay, is she going to be reading it, or Ms. Drummond, or you? Tell me how this is going.
Ms. Drummond is going to be reading it.
Okay, good afternoon, Ms. Drummond. You might need to send her something. She's not activating her screen.
Charges not fictional.
What? Right.
You know what we're going to do? I'm going to hear from Ms. Rios, and if there's something Mr. Davis wants to say, we'll certainly come back to this. We won't conclude. I won't accept the plea if I'm going to until I hear what Ms. Barber has to say through Ms. Drummond, but you need to get Ms. Drummond to come alive on the screen there. Let me do this first. Ms. Jackson, good afternoon. Do you have any criminal history information on Mr. Davis?
Yes, Your Honor. There are 6 cycles. The last arrest was October the 13th, 2013 out of Cobb County for driving while license suspended or revoked. That charge was null-prossed on December the 11th, 2013. He does have one one felony sentence. It was in 1989. For theft by taking. That case was sealed July the 6th, 2017. Nothing in addition, Your Honor.
All right. Thank you. And thank you for your time this week. You are good to go. Have a great weekend.
Thank you, you as well, sir.
All right. Ms. Rios?
Yes, Your Honor. Mr. Davis is 60 years old. He is from Atlanta. He currently works as a referee for football and basketball. He has 5 children and 13 grandchildren. He became a father at the age of 13 and got full custody of his son while he was at Morehouse. He also worked as the first Black person to be an accounts controller in 5 different counties. He has been a coach for 22 years. And he was working as also a coach and a behavioral behavioral specialist that works in schools to de-escalate situations. I know he wants to talk a little bit about the situation. As far as my understanding about the case, I did get some information from the school from myself because I did.
What school are we talking
Pitt
about?
Academy. And the packet that I got, they did an investigation initially and they found that he had no wrongdoing. Went from their interviews of people initially told him he'd come back to work. I think when these charges became with the police, then they were like, okay, you gotta. And so he ended up retiring from that or resigning at that time.